Hi, my name's Chloe Benson and today I'll be talking about forfeiture. I'm a lawyer at Goodman Derrick in the Property Disputes Resolution team, and in this video I'll be discussing the 3 important points for landlords to consider before deciding whether or not to forfeit a lease of commercial premises. So the 3 points that I'll be focusing on are the practical issues, the legal issues and the post-forfeiture issues. So firstly, before effecting forfeiture, a landlord must consider whether it's in his interests to terminate the lease and retake possession of the premises. If possession is recovered, then a landlord will need to think about whether there's an opportunity to relet the premises to a tenant with better financial standing. He'll also need to consider the risk of being left with an empty unit, which would expose him to liability for business rates and repair and maintenance. If you're concerned about the risk of an empty unit, then consider whether there's another remedy worth pursuing, such as the commercial rent arrears recovery or pursuing a third party for the debt. Alternatively, it's always worth having a discussion with your tenant to see if an agreement can be reached without legal action, such as a temporary rent concession or monthly repayments. So, the legal issues. Firstly, check whether there's an express re-entry clause in the lease and whether there are any preconditions, such as a 14-day grace period. Secondly, does a notice need to be served under Section 146 of the Law of Property Act 1925? Now, this is an essential and mandatory precondition where the breach is one other than unpaid rent. You need to ensure that you don't do anything which could waive the right to forfeit. Now, waiver occurs where a landlord or possibly a landlord's agent has knowledge of the breach but does something to unequivocally recognise it as existing or continuing. So examples of waiver could be demanding or accepting rent or exercising commercial rent arrears recovery. How to effect forfeiture? The act of re-entry may be done in one of 2 ways, either by physically regaining possession of the premises, that's commonly referred to as peaceable re-entry, or by issuing and serving court proceedings. Now, whilst peaceable re-entry is often a lot swifter and cheaper, it can lead to a lot of uncertainty. But on the contrary, court proceedings could take several months to determine the matter. So, considerations post-forfeiture. Firstly, upon re-entry, the landlord would become an involuntary bailee of the tenant's goods and will be responsible for their safekeeping. So a landlord will need to consider whether it will be able to look after the tenant's goods and how it will deal with them. Now, a tenant is able to apply for relief from forfeiture, and this is in effect an application by the tenant to the court to reinstate the lease. And recent case law has held that the 6-month prescribed limit in statute is a guide rather than a strict time limit. Finally, forfeiting a lease does not prevent a landlord from seeking relief in respect of any formal breach of the lease. So, a landlord can still sue for unpaid rent which predates the act of forfeiture. So, as a recap, whilst you might be keen to re-enter and change the locks the day after the tenant hasn't paid the rent, I'd always recommend considering carefully the practical, legal and post-forfeiture considerations. If you'd like more information on this topic, my details can be found below, and thank you for listening.